Good afternoon, good morning, wherever you might be calling in. My name is Dismas Locaria. I'm a partner in Venable's Government Contracts Group, and I'm joined today by my colleague Jenge Tamba, also in our Government Contracts Group. We welcome you to joining our monthly webinar session. This month we'll be talking about the top 10 deal considerations for government contractors. Really quickly, today's presentation is available for download on the webinar platform that you're viewing and listening to this from. And at some point during the session, you will receive your CLE code on the webinar as well. Today we plan to, as the title kind of indicates, we're going to talk about 10 major considerations for government contractors in a buy or sell arena. We're not going to be talking about typical corporate considerations. There's a host of those things, and there's a lot of great colleagues of mine here at Venable that can speak and talk to those issues. Today's focus is really to focus on what makes a government contract deal or a deal concerning a government contractor unique. So these are things you would not see typically or be concerned about if you're buying or selling a company that does not do government contracts. These are things that are very specific considerations that we look at when one of either the buyer or the seller is a government contractor. So we're going to talk about how the transaction type impacts that. We'll talk about preparing for the entire process, because that in and of itself is an ordeal. We'll talk about the purchase agreement and some of the issues and things we think about in the purchase agreement. We'll talk about due diligence from both the seller's and the buyer's perspective. One of the things is if you're looking at acquiring small business government contractors, there are a number of issues that come with that, so we'll talk about some of those. We'll talk about the security clearance issues. If you're buying a government contractor or acquiring a government contractor that has a facility security clearance, we'll talk about how that works. We'll talk about the impact of teaming agreements, and then also the impact of a deal on intellectual property and organizational conflicts. This is only an hour-long webinar, and we could probably talk about any one of these topics for an entire day. So unfortunately, we'll be touching on all of these topics, diving into them to some degree, but certainly we won't be able to discuss every aspect or every nuance of these issues, but mostly what we wanted to do is flag a lot of these items for you today. Also, if you have any questions throughout the presentation, please feel free to put those in the question box, and we will answer those either during the presentation at an appropriate time, at the end if we have time, or we might do that in an email following up the presentation. But with that, let me turn it over to my colleague Jenge to talk about types of transactions and the impact on government contractors.
Good afternoon. I am Jenge, and I will be speaking on the type of transactions. So the type of transaction in a deal is very important, as various transaction types impose different obligations. So there are two general types of transactions. You have a stock deal and you have asset deals. A stock deal is the purchase of the equity interest, such as shares and stock, of the target entity. It's the sale of only the ownership rights of the target that are being acquired. You do not have any assets in these. Conversely, in an asset deal, the buyer is purchasing the assets of a business from the target entity. With asset deals, because assets such as government contracts or teaming agreements are being exchanged, you do have to take into consideration novation and assignment requirements. So touching on novation, a novation involves three parties. So you have the seller, who is in contract with the government currently, as well as the buyer who is purchasing the government contract. So in a novation, the seller transfers the rights and the obligations under the original contract to the buyer, thus releasing the seller under the contract. A novation requires consent by all parties through a novation agreement, and this is because you have the buyer coming in and completely replacing the seller in that contract or that agreement with the government. Speaking more on novation agreements. A novation agreement is an agreement between the original parties of a government contract, so the government and the seller, and the buyer or purchaser who is seeking to replace the seller to that contract. FAR Part 2.101 defines a novation agreement as an agreement which is executed by the contractor or the seller, the successor in interest or the buyer, and the government. This is an agreement by which the seller guarantees the performance of the contract, the buyer assumes all the obligations under the contract, and the government recognizes the transfer of the contract and related assets to the buyer. FAR Part 42.12 prescribes the policies and the procedures for a novation agreement. So in this part, you would find recognition of the buyer in interest of the government contract where the seller's assets are transferred. It also provides a template for the type of agreements, and if you look, it requires a number of supporting documentation, including the transaction documents. Therefore, it's very important that a request for novation occurs only after the closing of a transaction to ensure that everything has been solidified and all those agreements have been put in place. Looking now to assignments in an asset deal. So when a stock or equity interests are transferred, an assignment is when the seller transfers the contractual rights and the benefits it holds under the contract to the buyer. There is no transfer of contractual obligations. The burden of the original contract remains with the seller at all times, and the contract liability risk, likewise, also remain with the seller. It is very important that the seller protect itself from potential liability, and this can be done by obtaining an indemnity from the signer or from the buyer. And an indemnity is a security or protection against a loss, which will be discussed a little bit more in detail later.
And one thing to keep in mind, the novations relate to assignment of the prime contract between the government contractor and the federal government, whereas an assignment is likely to be between the prime and the sub. The federal government just likes the word novation to use instead of assignment. And in terms of novations, from a practical standpoint, the timing of them, as Jenge mentioned, they happen post-close. And so the implication of that is, you've gone through your transaction, you've now closed and wrapped up your transaction, now you need to move these agreements after the fact. So it's obviously critical to make that happen, and sometimes the government may have questions, issues, concerns as to how those are transferred, the ability to perform, those types of issues may come up. And again, this all comes up post-transaction. So just things to think about is the likelihood of a novation being approved. We've had very good success. It can vary, the timing can often vary, and there's ways to mitigate kind of the impact of the timing, but it can take anywhere from a number of weeks to several months to get a novation approved by the government. So it's one of the things to think about whether you do a stock deal avoiding the novations or do an asset deal where you have to do a novation. So one of the considerations to think about in that process. Sometimes there's other reasons why you need to do an asset deal, but certainly a stock deal is more advantageous in this regard because you don't have to do the novation.
So certain contracts with the government will require notification of ownership changes when in an asset deal, and those requirements are found at FAR Part 52.215-19. It says that the contractor shall make the following notifications in writing. You must notify the contracting officer within 30 days once you become aware that a change in your ownership has occurred or is certain to occur, which could result in changes in the valuation of the capitalized assets. Also, you must notify the contracting officer within 30 days whenever a change to asset valuations or any other cost changes have occurred. So when you're focused on an asset deal and just purchasing shares and equity, you have to make sure you do a thorough review of your government contracts to ensure that if there are any notification requirements, that the contracting officer is notified within a timely manner. Next, we're going to discuss preparation. Preparation is very important to deals because it impacts the valuation of a deal, and also it impacts understanding fully what your government contracts require. Organization and documents. There are lots of documents that take place from a government that are involved when you are looking at a deal from a government contracts perspective. Most obvious is your government contracts and subcontracts. The FAR requires that government contractors retain contracts and subcontracts 3 years after the final payment has been received. So even though you are done with your contract performance, to comply with certain audit requirements, it is pertinent to keep and retain your documents 3 years after. So if the deal is occurring after performance of a contract, you still need to keep these documents and transfer it along with the deal. Contract modifications are also very important because they deal with any changes in the contract during the duration of that term. The proposal pipeline is key because it helps you understand the representations that were made from a small business perspective or other perspectives during the proposal. For both seller and buyer, the size standards, impacts of the deal, and the size requirements, the size standard representations made to the government proposals are important. Diz will discuss more about this when he talks about small business issues later on during this presentation. There are certain agreements that should also be organized and brought up in the preparation stages, including teaming agreements, joint venture agreements, and mentor-protege agreements.
So, as Jenge mentioned, the preparation is significant in terms of a deal, and that's not uncommon, I guess, with respect to a commercial deal as well. Another major thing that we often get involved in is and Jenge will talk about the diligence side from a government contracts perspective, but is the actual nuances of the purchase agreement. So this is the actual agreement that's going to transfer the ownership or the stock or the assets from the buyer or from the seller to the buyer. And obviously these purchase agreements you'll see those in every context, but there's a few things to keep in mind from a government contracts perspective. So much like a normal purchase agreement, you're going to have reps and warranties, but in this situation, we're going to have reps and warranties that are specific to government contractors. Those of you that are familiar with this, reps and warranties are essentially the assertions that are made in a purchase agreement that are relied upon principally by the buyer, right? The seller says that X, Y, and Z is being conveyed to you. These are the liabilities, the contingencies, whatever the issues are that might be transferring from the seller to the buyer. Conversely, the buyer is making representations to the seller, typically about the funding and things along those lines, but they go back and forth, and these reps and warranties are what would underpin, if there's problems down the road, would underpin any liability that we didn't know about this, we bought this, we didn't realize it had this issue, you were aware of it. So these reps and warranties are significant from a long-term perspective when you're looking at an acquisition. With respect to government contracts, there's always this concern about how significant are these reps and warranties. You want to make sure that the language is narrow and specific if you're the seller. From a seller's perspective, you want to make sure that the reps and warranties that you're signing up to are specific to the things that you are aware of, both in writing or orally, and make sure that you're limiting your liability through the breadth of these representations. From the buyer's perspective, the general rule is you want it to cover things broadly. You want to cover as many issues as you can. And so kind of with that umbrella, let's talk about some of those that are specific to government contracts. So first of all is, the buyer wants a rep and warranty from the seller about what it's buying, which is essentially a list of all the active contracts, subcontracts, bids, teaming agreements, JVs, mentor, protege. And Jenge makes the point also with respect to contracts, even though the performance might be complete, especially if you're doing a stock deal, the liabilities may not be completely resolved. And so you want to even maybe know about past contracts that are done, but liabilities might still be hanging out there. So the first thing you want, or what's first is typical, is reps and warranties about the active contracts, the active bids, the contracts that were recently performed, as well as some of these side agreements like subcontracts, teaming arrangements, joint ventures, and mentor protege. So you first need to have that understanding. Then you want to know, often we want to know whether or not any of these awards were predicated on a size status. And that's going to get in, and we'll talk a little bit more about small business issues. But that's one of those things that if, in the government contracting space, as many of you may know, you can be awarded based upon being a quote-unquote small business or a woman-owned small business or a service-disabled veteran-owned small business or an 8A business hub zone. There's all sorts of different designations that give you preference and sometimes give you exclusivity to seek a government contract. In certain cases, it may give you a preference because you're small. In other cases, it may give you exclusivity. In other words, the contract might have been set aside for your status, and you want to know which contracts had the preference or have this set aside status because we need to assess what the impact will be for the buyer. Right? The buyer may not be small. The buyer may not be woman-owned, veteran-owned. It may not have those designations, and so we need to understand what contracts are predicated on those and what the impact would be. Also, we want to know, were you validly asserting your woman-owned status, or were you validly asserting your 8A status? And so understanding what contracts were predicated on the size status is critical. There's also reps and warranties about non-compliances. Now, typically, it's narrowed to material non-compliances, and we're lawyers here, so we could debate materiality all day. But essentially, we want to know about significant non-compliances, and so that sometimes requires companies to kind of, let us behind the curtain and understand what some of the problems are, if there are any. And so, but that's a critical thing, is that if there are no non-compliances that aren't represented in the purchase agreement, if those come to roost down the road, there could be liability on the seller for not notifying the buyer of those issues. Performance issues is key, right? Do we have a government contract that's going to fail? Do we have a government contract where there's been a show cause or any other kind of concern by the government? Are we inheriting a problem? In other words, is the buyer buying a problem? So they would want to know about those types of things. IP encumbrances. We'll talk about intellectual property in more detail, but are we buying intellectual property that is encumbered by the federal government's rights? Another critical issue. The buyer will typically want to know about audits, investigations, disclosures. Again, problems that the seller might be experiencing in its work. Disallowances. So the federal government will often, under certain types of contracts, has the ability to what's called disallow certain payments because they might be predicated on cost or some other type of arrangement, and the federal government doesn't pay certain kinds of costs. And so there may be disallowances out there that the seller's aware of and the buyer wants to be aware of or made aware of through the reps and warranties section of the purchase agreement. Past or present investigations, allegations of fraud, bribery, and other integrity-based violations. This is a significant issue that buyers, again, will want reps and warranties on to make sure that there's not any underlying problems that could come to roost after the fact. And that kind of leads into the next one, which is past or present debarment, suspension, and non-responsibilities. Again, these are typically based upon fraud or integrity violations. And so has any of that occurred? Is any of that ongoing? Again, a very relevant inquiry for a buyer. And then the last is, or at least the last in this list, and it's not necessarily an exhaustive list, but this is pretty exhaustive. The last is, what are, if any, the security clearances and classifications required to perform under the seller's existing contracts?
So both in the commercial space as well as the government contract space, due diligence is very important when it comes to deals and transactions. We will discuss today due diligence from the seller's perspective and then switch over to talk about it from the buyer's perspective. Really
quickly, before Jenge jumps into our next topic, someone does have a question relating to the reps and warranties. It says, do you have any advice on how to deal with employment law issues like wage and hour, non-discrimination, traditional labor law, et cetera, in the reps and warranties? So I do, with respect to government contracts perspective on that. Certainly there's a host of labor issues that my colleagues could speak to: Family Medical Leave Act, Fair Labor Standards Act, those types of things. And I don't see any reason why those could not be wrapped up in a rep and warranty. But there are also a number of employment laws specific to government contractors. Affirmative action plan requirements, Davis-Bacon law, Service Contract Act, which are wage and hour provisions, and those are often part of that, those reps and warranties that deal with non-compliance. If our seller is, let's say, a construction company, Davis-Bacon and Service Contract Act can be significant players or pieces to a services business or a construction company. And so the reps and warranties about material non-compliances may even cite specifically to the Davis-Bacon laws or the Service Contract Act to make clear that those, we want to make sure there's no problems with compliance with those types of laws. So you can absolutely address the labor type issues in your purchase agreement. So let me turn it back over to Jen Gay on the diligence.
Okay, so talking about diligence from the seller's perspective. So in completing its rep and certifications, the seller must ensure that it collects all the information that must be put into the disclosure schedules. So the types of information that's put in schedules include the contract types, whether it's time and material, firm fixed price, just disclosing what type of contracts they have with the government or subcontracts with subcontractors, the duration of those contracts, so the terms, as we discussed earlier, whether it has ended already or you're currently performing the contract, the duration is really important. The value of the contract, the key IP-related terms of the contract, notice of changes in ownership and assignment. As I spoke about earlier, certain contract terms and certain FAR requirements require that you notify the government within a certain time frame of any changes that are going on in ownership or assignment. Potential warranty issues that may arise, and small business designations. So these are just a few things that the seller must ensure is put in the list that are very pertinent to government contract fields. Due diligence from the buyer's perspective is a bit different. As a buyer, you're purchasing this deal and you're purchasing these assets from the seller. You need to ensure that you do a thorough review of the materials that you receive from the seller to make sure that what you're purchasing is of value and is understood by both parties. So you're reviewing the schedules that the seller sends over, going through all the documents, the contracts, the terms, and you're also reviewing public information, including looking at sim.gov to see what the seller has put on there, looking at various websites, the World Wide Web, and the public information available out there. It's important that the buyer does a risk and a liability analysis to ensure that what they're purchasing is of value and to make sure that you're not buying problems. Some potential risks that buyers should be aware of, as this discussed earlier, things such as show cause notice, which is an order that's issued by the government for explanation of an incident or a misconduct, asking why the government shouldn't take any disciplinary actions. A notice of default, which is a notice from the government of a breached contract resulting in termination for default, or notices relating to suspension or debarment. All three of these are very important to flag in the schedule, and these are important that the buyer knows of because it goes on the contractor's permanent record, and it could impact and have lasting impacts on your ability to contract with the government in the future. It may be very difficult to obtain future government contracts, and if this is a field in an area you want to continue practicing in and working with the government, you should be aware of some of these risks that you could be buying.
So let me jump into small business issues. I touched on this a little bit before, but let me dive into it a little bit more with a little bit more specificity here. So as I mentioned, there's a whole host of different status that you can have as a government contractor. You can be small, and we can go into what that means and how you're classified as small, but that's a whole nother webinar in of itself. You can be a woman-owned, WOSB, woman-owned small business, a veteran-owned small business, an SDVOSB, which is a service-disabled veteran-owned small business, an 8A small business, a hub zone, and there's some others like disadvantaged business. So you can be any of these different status as a seller, and the buyer needs to know, and they need to understand, again, which contracts are predicated with that status. Many of them, if you are small or any of these statuses, likely that all the contracts you represented that in all of your contracts, that you were that. But it's particularly of interest on whether those contracts were set-asides, because how they're treated if it was a set-aside is different if it's full and open. If you're a full and open competition, meaning big companies, small companies, everyone can compete, and you're awarded a contract as a small business, the government gets credit for that, but it was open to all kinds of businesses. So the transfer from, company A to company B isn't as big a deal because it was awarded on full and open, and even though the government will no longer get credit since company B is not, let's say in this example, is not small, the government's no longer going to get credit, but the contract does not have to be terminated or any other action taken, so the contract can continue going forward. And in those positions also it's important because here company A as a small business was competing against large companies and still won the contract. The government does have percentages it's trying to meet, but typically one of the challenges small businesses have against big businesses is technical capability, being able to match their technical capabilities against the big guys. Well, that's a great small business if they can beat out a big company based on technical capability and everything, and the government gets a bonus with the credit. But chances are that company will be viable even after it's no longer small. And if you as a buyer are not small and you're acquiring a small business, by that very nature, it's going to lose that small status. It is extremely difficult to create a situation where they're going to maintain. It's not impossible, but it does require a lot of different machinations for a small business to maintain that status if it's being acquired by another company. Chances are it wouldn't be able to be a majority ownership. It would have to be broken up into various pockets to maintain that status. So for ease of our discussion, when it's being a small business being acquired by a non-small, we're going to just say it's affiliated and it's not going to be small. So how do we know? So contracts very rarely say on their face that this was awarded as a set-aside. The proposals and the RFP often do. A request for proposals will say if it's set-aside or not. And the proposal documents that a company submits might often say that. So those are helpful to look at to know whether something's set aside. Sometimes the cover page of the contract will say that it was set aside for small business, but not all of those cover pages are the same. So sometimes we'll have to look at the document and see what kind of provisions are included. And one of them that we look for in particular, because this clause is required in all set-aside contracts, is FAR provision 52. It should be 52.219-14, not 19. But FAR 52.219-14 is the limitation on subcontracting clause. And that, like I mentioned, is required in all small set-aside contracts. And so that will usually give us an indication that the contract that includes this is in fact set aside for small businesses. So why is that important? Well, let's talk about it. So if the seller was small at one point in time, there's a bunch of issues to consider. As I mentioned before, you often have them provide reps and certs as to the accuracy of that. Unfortunately, the small business regulations are pretty complex and not that simple and intuitive. The affiliation rules are constantly evolving and changing with OHA, the Office of Hearing and Appeals within the SBA. And so it's not uncommon for companies to think they're small when in fact they're not. Now, sometimes that can be borderline fraud, but a lot of times that can just be plain mistake. But it doesn't negate the problem, which is if you were awarded a contract as a set-aside and you weren't eligible, then you shouldn't have gotten that contract. And that's a problem for another company to buy. So we look at that. We often look at SAM.gov to see how a company has represented itself over time. We want to understand the corporate dynamics. For instance, when you're dealing with women-owned or service-disabled veteran-owned or veteran-owned businesses, the woman, the vet, the service-disabled vet, and same with 8A, they need to be directly owning the entity. In other words, there can't be a holding company. And so sometimes if we look at the corporate makeup, we say, how can you be a veteran-owned business when you have an intermediate company? Because that veteran, the person with which the status relies, has to be a direct owner. And so that's one flag for us. Another flag is control, right? If it's a woman-owned business, is the woman involved in the company? If she's not, well, that can be an issue and something that a buyer would want to know, because that could come home to roost later when someone argues that, no, they were awarded these contracts when they were never a woman-owned business, and these contracts should be terminated. So those are some of the issues that we need to look at from a size, status, accuracy standpoint. Now, attempting to maintain the status post-transaction, I talked about this a little bit. Some of these statuses you might be able to maintain depending on the size of the buyer and the makeup of the buyer. In other cases, it might be more challenging. So you really want to understand what the buyer is trying to accomplish with the acquisition, and what the kind of makeup of the buyer is, what the makeup of the seller is, and what the makeup of the combination will be. So that's something that we definitely analyze early on in the process. Now, how do you value some of these contracts? And we leave it to people far smarter than I that can work numbers and whatnot to actually do the valuation. But it's critical to companies to know how much of the business is predicated on set-asides. When you determine the value of a company, are they 100% reliant on set-aside contracts? And when this deal closes, they're no longer going to be small? That impacts the value of the company going forward. Can they win work? Does the company have enough assets to win work even though they're not small anymore? So that's something that we absolutely look at and consider from a small business perspective. Then there's the impact of the transaction. What is going to happen if we're just small? What happens post-transaction? As I mentioned, if you're just small, your contracts don't have to be terminated. But let's say it's an 8A or a hub zone, and you make that move. If you're an 8A, there's actually a requirement that the contract be terminated unless the SBA waives that, because the agency seeks a waiver, and the SBA would potentially, or at least has the authority. If an agency seeks a waiver, the SBA can waive that mandatory termination. So on 8As, it's especially important to understand what the impact of the transaction is going to be, so you can plan for that, seeking that waiver, and then knowing what the plan will be post-transaction. And then there's a host of notice obligations that come into play. As I mentioned, on 8As, there's this potential termination of the contract. So there's essentially a pre-closing notice that you're going to need to provide in order to get a waiver. On the other, when you're a small business or a woman-owned business, it's a little bit different. You don't have that pre-notice, but you do have a post-close notice within 30 days, different from the one that Jenge talked about earlier. These are specific notice obligations under the SBA, the small business rules. And so you want to make sure that you kind of catalog all the notice obligations that you're going to have, and you have to update your SAM and all these different things within 30 days of closing. So you make sure that you've got this stuff covered when the time comes. Okay, next let's talk about security clearances. So security clearances are pretty specific because they obviously relate to situations where a company has a classified or a top secret or some type of clearance, typically with the Department of Defense, or one of the intel agencies, but it could also be with DHS, Department of Justice, Department of Energy. So there's a host of agencies, Department of State, that have contracts that fall under or that require a security clearance. And so, understanding that at the get-go is also very important and something you need to know well in advance of closing. So does the buyer have a facility clearance, is what they call it, an FCL, right? And will the buyer and the seller have the same level? So what am I getting at here? So if you have a buyer that has never had a clearance and they're looking to acquire a seller with a top secret facility clearance, depending on how you structure it, the general rule is that the buyer is going to have that top secret clearance. Now, there are things you can do, and we'll talk about mitigation, to avoid that. But the general rule is that the top of the organization has to have the same clearance as the operational entity. So if the buyer has no clearance and the seller does, then that's something we're going to have to deal with. We're going to have to look at going forward. So some key considerations. Well, first of all, is understanding what your obligations are going to be. FCLs and security clearances are dictated under what's called the NISBOM, which is a manual that National Industrial Security, I forget what the PO part is, manual. And the NISBOM dictates how clearances are supposed to be, or classified information is supposed to be handled. So the company, the buyer, is going to have to get familiar with that. Now, if the seller already has a clearance, then, hopefully the people, if it's a stock deal, everything's going to move over. But hopefully if it's an asset deal, the people that have the understanding of these requirements are going to be staying with the company and moving with the transaction. Because part of it is having what's called a facility security officer, an FSO. And that FSO is the primary interface with the federal government. And so hopefully that FSO will remain with the seller. But if not, that's certainly something that we have to think about. Now, the other key aspect, though, at the outset here is understanding whether there'll be any foreign ownership, control, or influence on the side of the buyer. By that, the issue is the seller has gotten a clearance, and so whatever foreign ownership, control, or influence there might be on the seller's side, that's been handled already. But if the buyer is coming in and has investments from foreign countries or U.S. entities that are controlled or influenced by foreign entities, those can be issues, and those are things that we need to know early on so we can then figure out a way to mitigate that. So when there are foci issues with the buyer, we need to come up with a mitigation strategy. So it depends. A lot of it is going to depend on what exactly are the facts around this foreign ownership, control, and influence, because there's a range in complexity. I can tell you it's a lot more complicated if the Chinese government is looking to buy a U.S. government contractor that does work for the Department of Defense. In fact, that would probably be unmitigable because the U.S. government is not going to agree for China to buy a major U.S. defense contractor. So, there's some common sense to this. But if you're looking at, let's say, a NATO ally that might be investing in or might have an investment in a PE company, a private equity company, and that private equity is looking to buy, and let's say it's a domestic private equity, and that private equity is looking to buy a government contractor, that's a whole different ballgame, right? So sure, you have foreign influence, and you probably have some foreign control over that private equity by a foreign entity, but it's not unmitigable. So you have to look at what the influence is, and then there's a range of solutions that the Defense Security Agency Defense Security Service, the DSS can implement. Typically, what we advise is that you don't wait for them to tell you what to do; you offer it up. So, based upon our experience, under these facts, we think a board resolution might work. So, what's a board resolution? So, a board resolution is that, let's say, in this context, the seller is being acquired, and you have the company, the stock is being acquired by a private equity firm. And the board of the private equity firm is made up of, 13 people, 9 of which are U.S. citizens and 4 of which are not. Could we, and those 4 are from NATO, kind of NATO type allies. Could we just have a board resolution that that the private equity, and this kind of construct is maybe too simplistic because chances are private equity has a lot of other dealings, but let's say it's an entity that has these 13 positions. Is it possible for that board or that buyer to get a clearance? And if it can get a clearance, but you have a few board members that are not U.S. citizens, you would then implement a board resolution that would exclude those board members from receiving any classified information. So you essentially have a resolution that says, and there's templates for this, that would exclude certain parties from access to that information. So that's the most innocuous of the mitigation steps. You have various types of security agreements, which are essentially a contract that says, we will do X, Y, and Z throughout the period in order to maintain the clearance for the company. So that's a little bit more formal. You have an agreement. It might have audit rights. It might have reporting obligations. It might have various aspects that DSS, so they have a little bit tighter grasp on the company and what's happening there. Then on the far side, you have what's called a proxy board. And in that situation, what you have is a situation where DSS says, look, we're not comfortable that the top level entity has the same top secret clearance as the seller. We think that there needs to be an intermediary organization that is made up of U.S. people that call the shots with respect to this entity. And so that is what's called a proxy board. And so what you do is you end up filling a board with, in most cases, you put a board together, usually a lot of kind of retired generals and retired military people whose mission is aligned with the seller's mission. And that gives DSS a lot more comfort that they have these kind of retired military folks overseeing the operations, and that the classified information can trickle up to them and they can make informed decisions about the operation of the company. And then anything that trickles up to management beyond that proxy board is unclassified, typically financial type information that might trickle up past the proxy board, through the proxy board. But that board serves as kind of a firewall between this company with the clearance and the parent company that DSS is not comfortable providing a clearance to. So all of that is something that needs to be thought of and, kind of marinated pre-closing. But the way the government works, similar to novations, everything actually happens post-closing. So because they want to see that the deal is done, then it all happens post-closing. Now, it's never a good idea to say, okay, seller with the top secret clearance closes a transaction on September 1st with buyer that has foreign influence and control. You don't call DSS up the next day and say, hey, by the way, we are now owned by XYZ company as of yesterday. Technically, you can do it that way, but the experienced practitioners will always tell you, you want to give DSS a heads up. You want to reach out to them informally beforehand. Usually we like to do it at a point we know this deal is going to go through. So you don't want to do it necessarily when you're still at the LOI stage, and you want to do it when you're pretty far down the road, and then reach out to DSS at least a couple weeks in advance and say, hey, look, we're shooting towards a September 1 close date. Here is the situation, our seller, and then there's this buyer. Here's the makeup of the buyer. If we were going to submit the documentation that's required post-close, this is what it would look like. Given this structure, we think it might be best to do that only a board resolution is necessary, or that you're going to want a security agreement. We're fine with that, or we think you're going to think a proxy board is necessary, and we're okay with that, and we've explored that, and here's what we propose. So you want to come in with kind of a plan to your DSS rep. Now, this is all done in conjunction with the seller's facility security officer, because that FSO and their DSS representative have a relationship. So they may have a good sense of what the DSS rep would want, how much notice they would want. So these are all things you kind of figure out early on again and all pre-close. But absolutely something you want to do pre-close, because you show up at DSS's door post-close, they're going to be probably pretty upset they weren't given a heads up when one of their contractors is now controlled by a foreign company, even though they hold a security clearance. So that's kind of the quick primer on security clearances. Let me turn it back over to Jenge.
So just like government contracts, teaming agreements are quite important to review, and they usually involve just two private entities and not an agreement with the government. So it's important for you to look at the exclusivity requirements that are in the agreements. And from a buyer's perspective, this is very pertinent, because if the buyer is involved with another party and the current transaction or deal would cause the buyer to be non-exclusive to that other party, some notice requirement may arise, and the buyer may need to notify the other party and seek consent before completing the deal. Non-assignment clauses also appear in teaming agreements that require consent or that require notice before assigning a contract from a teaming agreement, from the seller to the buyer. So these are important things to review and to take note of to ensure that after the deal, the teaming agreement is still intact. It is only important to look at active teaming agreements. Once the teaming agreement has ended, unlike government contracts, you do not need to keep it around for a certain amount of time frame. And so back again to Diz to talk about intellectual property.
Thank you. Okay, so let me talk a little bit about IP. We touched on this before as part of the kind of reps and warranties section, but let me talk a little bit more about why it's so important. So a buyer is going to be interested in the assets it's buying, and among those assets, oftentimes you're buying contracts, but oftentimes one of the, if not the key asset in an acquisition, is the intellectual property. And you're only as good as the rights in those assets. And so what does that mean? Well, intellectual property is something that, I think a lot of companies develop, but aren't always that careful with how they preserve their rights. And what do I mean by that? Well, the first thing is the government buys a lot of stuff, and sometimes it buys services, and sometimes it buys services that are actually development services. And so it might buy software as a service, a SaaS, and that is usually pretty clear that the software is probably commercial in nature and developed at private expense. But if the government is looking for the development of something, you start to get into whether or not the IP is developed at public expense. And the development and who paid for the development is a critical issue on who has the rights. Now, you as a developer will always have a right with the government, even if the government pays for it. But if the government has paid for it, you'll always have a right to it. But if the government has paid for it, then the government may assert that it has what's called unlimited rights. And why does that matter? Well, unlimited rights means the government can do with the software as it chooses, or the IP as it chooses. Well, that's fine, right? But I can still sell it commercially. Yeah, you can still sell it commercially, but the government can also give it away. And that's not to say the government's going to give it away, but they can do with it whatever they want. And so that means, you develop some software, some IP for them, and you're, moving along in your contract for 12 or 15 years, and, now there's a new program person, and they don't like you as much. And the government says, you know what, we're going to go to this other contractor. And you say, well, no, you can't just go to them. This is our software. It's our proprietary software. You can't just hand it over to them. And they say, well, you know what, we think we've developed this. We paid for the development of this. So yeah, we can just hand it over to that company, and they can do what you were doing, because we can just give them the IP. And then you say, no, we developed this at private expense. This is our IP. And then they say, okay, prove it. And so that's where companies run into some problems, because they can't always prove, or they don't keep the records to always prove that the intellectual property was developed at private expense. And the government has the ability to essentially give it away if it wants, if it has unlimited rights. So it's important early on to understand if you're a buyer, to talk to the seller about how they have preserved their IP portfolio. Is it without question that it's been developed at private expense? It's a completely commercial platform or commercial IP that is clearly developed at private expense, or has the government got involved? Now, a lot of times what we see is IP that is, let's say the basic IP is developed at private expense. And then there's some configuration and development of the IP at public expense. So the government may have a right to that piece of it, but without the basic underlying platform, it doesn't really do much. So that's not as concerning to us. Where we get concerned is that the development then morphs into something new. And if it develops into something new that is no longer predicated on the base IP developed at private expense, that becomes a challenge, and that IP may be encumbered and may not really be of all that much value if the government has unlimited rights. Similarly, you have issues with patent protection. So there's kind of data rights and information that you have to be concerned about, but you also need to be concerned about patent rights. And patent rights, even if the government pays and you come up with an invention in the course of a government contract, you can patent that. The government's not in the business of patenting things. You can patent that. But typically you have to preserve that patent right. You typically have to provide the government notice that an invention has been identified, and that you are moving forward with the patent, and you have usually a certain prescribed time period to do that. So the question is, have you properly perfected your patent rights? And if you've not, then the government may argue that no, like we can give this invention to another contractor to do work for us under that method or that approach or whatever the invention is, and you might lose your patent rights. So again, IP needs to be protected. It needs to be, you need to keep track of how your IP is developed, who paid for it, and then, and I didn't mention this, you also need to be sure to tag your IP correctly. So if you're bringing IP, a lot of contracts say, if you're bringing IP to this contract, you need to let us know at the outset. And a lot of contractors don't do that. And so it puts a cloud over it, right? Now, a lot of times you can kind of fix that after the fact. No, we forgot to notify you at the outset that we were bringing this IP, but clearly this is developed at private expense, blah, 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 blah. You can get into that. But, people should be mindful that the contracts often say, you need to tell us what IP you're bringing to the table. And are you properly marking the IP? So a number of FAR provisions and DFAR provisions have notice requirements that the IP is supposed to have a legend on it that says it is being brought to this contract number, and developed solely at private expense. That is the way to preserve that IP without any objection. So you want to be mindful of how, if you're a buyer, mindful of how your seller has protected its IP, has it perfected its patents. Because if it hasn't, and a dispute comes up down the road, you're then going to be trying to prove things that are sometimes very difficult to do. So a very important consideration, especially when IP is a critical asset for the deal. So let me get into number 10, organizational conflict of interest. So there's a couple parts to this that I want to talk about. But first, what are OCIs? So an OCI is first where a government contractor may be doing one thing for the federal government, and then it would have an either unfair advantage or it would have an ability to manipulate the playing field for another opportunity. And let me give an example of that. Let's say NIST has hired a company to develop certain standards. Standards that the company's sister company, let's say, that is in the business of testing certain things, is going to be subject to. Well, there's a potential bias that might exist that, company A is trying to make life easier for its sister company, company B. So there's a potential organizational conflict of interest. And there's three general types of conflicts of interest. One is unequal access to information. Now, the main issue there is if you're an incumbent contractor, do you have unequal? You have definitely access to information as an incumbent contractor, but that has been considered not a conflict of interest. Incumbent contracting is not, incumbency is not a conflict of interest. But unequal access to information, for instance, if you inappropriately received information from someone, well, then that's not fair, and you have an organizational conflict of interest. A bias is kind of the second one, which is the one I just kind of articulated, that you would have bias in terms of how you write these standards, so our company has has an easier time doing its work on the backside with the standards. The third is the ability to affect the ground rules. Similarly, if you're writing the standards to something, or let's say in this context, let's say I am writing the standards for a security program of a facility, let's say. Well, my company, my sister company, is in the business of electronic surveillance security. So I'm going to write these standards to not require people, but be heavily electronic security surveillance, heavy on that side. Again, better positioning my sister company that implements those plans, those programs, to win that work, right? Because they have written the ground rules that better position them or a company that they're related to profit from it. So those types of organizational conflicts of interest are things we need to think about. Now, two issues there. One, the reps and warranties of the purchase agreement will include usually a provision that says, and there's no knowledge of organizational conflicts of interest. And so has the seller done a good job of identifying organizational conflicts of interest? And if they have, great. They may have a mitigation plan, and if they have that plan, usually we'd want to look at that to make sure it's a solid plan, it's been approved by the government. And then the second issue is when the buyer acquires the seller, does that in it of itself create organizational conflicts of interest? So now you have one entity, now you have two entities, right? You have a buyer maybe with an existing business and a seller with an existing business. Does one develop standards and one implement? Through the acquisition, are we creating conflicts of interest? And if we are, then this acquisition might not be a good acquisition, or it might be something that we need to examine and figure out whether it's something you can mitigate, or it's just not, maybe they're two different industries. But it's definitely something to look at, is what's the impact of this sale on the buyer's existing business? Does it create conflicts of interest? And a lot of times that issue is not examined by buyer's counsel. And once they acquire that seller, now they've got all these conflicts of interest they didn't identify, and they're supposed to now update all their contracting officers about it. And if they fail to do that, there's potential false claims. So there's a whole host of issues that can come from it. So making sure you understand if the marriage of the two companies makes sense and doesn't create additional problems. So that gets us through the 10. I apologize if we went quickly at times, but there's certainly a lot of information, but we wanted to flag these issues for you all. I do believe I have at least one other question that I'll answer, and if others want to submit questions now, we'll try to answer as many as we can in the last couple minutes here. So question number 2 is, what is the impact of the loss of the small business status on existing contracts? So it depends on the type of status. As I mentioned before, an 8A status, you actually would potentially lose the existing contracts because under the rules, the default is that the contracts be terminated and reawarded, but you can seek that waiver. Under most of the other statuses, there isn't an automatic termination, but there is a loss of credit to the government. So that always gives the government the ability to terminate for convenience and maybe reprocure. One of the things we do to try to mitigate that is the sellers will often try to demonstrate their stickiness with their customers. And that may be through existing information, or they may even be willing to, the sellers may want to make phone calls to contracting officers, to program offices and say, hey, look, this is on the horizon. We're no longer going to be small. Do you think that'll impact your desire to continue business with us? And, in my experience, we've done that a number of times on sellers' behalf, and I've never seen the customers say, "Oh no, we're definitely pulling this contract because the only reason we entered into it was for the small business credit." I mean, 99% of the time, at least in my experience, the program office, the agency is with the contractor not because of their status, but because they do good work. And so if you're doing good work for the government, they'll get over the fact that they're not going to get small business credit any longer. And typically, and I've not seen contracts terminated for convenience on that basis in the past. So with that, we're at the hour mark. If there's any further questions, please feel free to email those to us. Otherwise, I appreciate your time today.
Thank you so much for listening.
And next month, we have a presentation with our partner and friend, James Bolin, on requests for equitable adjustments and claim-related issues. So please tune in for that. That's scheduled for September 26th, again, from noon to 1. Thanks so much for tuning in, and see you next month.